I'm going to be totally honest with you here. I am not sure what exactly happened this afternoon, but something big definitely happened to the policy of kicking people out of the military for being gay. Here's the big clear headline. This is the part that makes sense. And this has never happened before, and this is a big deal. An injunction barring the enforcement or application of Don't Ask, Don't Tell, effective 12 October, the Department of Defense will abide by its terms. Military lawyers today issued legal guidance to U.S. military commanders worldwide, telling them that, at least for now, our military is no longer enforcing Don't Ask, Don't Tell. It's a big deal, right? I mean, this has never happened before. Any existing discharges or separations or investigations or other proceedings that are pending now under Don't Ask, Don't Tell are halted. Any enforcement or application of the Don't Ask, Don't Tell rules is no longer allowed. Never happened before. It's never been done. Military is no longer enforcing Don't Ask, Don't Tell. For now. This is a huge milestone, don't get me wrong. For the first time since the policy went into effect 17 years ago, the policy has been stopped. The ban is not being enforced. Huge deal. But for how long? The Stop Enforcing the Gay Ban letter says the military will no longer implement Don't Ask, Don't Tell, quote, in the meantime, while the government decides whether or not to appeal the court ruling that said the policy is unconstitutional. Today, the Justice Department, in fact, did say it's appealing the ruling and asking for the policy to be kept in place while the appeal is heard. So the military is stopping the policy. The Justice Department says it wants the policy to stay in place. Imagine you're a gay 18-year-old in the Army right now. What do you think of today's news? Yeah, the president today was asked about and reiterated his position against the ban, but he said it is not in his power to unilaterally get rid of it. He says he needs the Senate to vote to do that.
This policy will end, and it will end on my watch.
Okay, but does the president control the Senate? No, he does not. Why is he confident that the Senate will end it? That is inexplicable to me. Does he have another plan to end it if the Senate doesn't vote to end it? That's what I want to know. And now that the enforcement of the policy is suspended, at least for now, can gay people go enlist in the military tomorrow if they want to? Joining us now for the interview is a man who is more likely to have answers to these questions than anyone else we can persuade to be on this show. He is Walter Dellinger, former Solicitor General of the United States of America. Mr. Dellinger, it is an honor to have you on the show. Thank you for your time, sir.
Thank you.
So let me ask you the smaller questions first and lead up to the bigger ones. Sure. Since enforcement of the policy is now suspended by the military, should an openly gay person today, now, be able to enlist?
No. I think this is a very temporary moment. What's happened is this. The district court has issued an order, and the order says do not proceed with any investigations, do not proceed with any discharges of any person in the military on the grounds of sexual orientation. And the Department of Justice is going to appeal that ruling. They're going to try to get her order stayed, that is, its effectiveness postponed during the appeal. But until they do, the military wants to make sure that it is not violating the order, which is in place at the moment.
So would you expect that the military will do a U-turn and start enforcing the policy again if this injunction that is halting it right now gets lifted?
Well, it's, I think that's unclear about how fast the military would want to process any cases or proceed with any investigations while this matter is pending. This order of the district judge will be stayed on appeal, either by the Ninth Circuit or by the Supreme Court, because the court will not want it to go into effect until they've had a chance to hear, full briefing and argument on the question.
So do you agree then, it sounds like you agree, that gay people in the military are still not safe to come out, and the issue of being an openly gay person and trying to join the military, even for right now, is not at all settled?
I think that's right. Now, the president said that this will end on his watch, and he's actually moved the ball pretty far down the road to making that happen, because the president has gotten the chairman of the Joint Chiefs to agree that the policy should end. He himself has stated unequivocally that it undermines our national security, and that's going to be a powerful argument in court. I think the government really has no choice but to appeal the case because we don't want a system where a single federal judge can invalidate an act of Congress and the president simply say, well, that's it, we're not going to seek to appeal that. Imagine, Rachel, 3 years down the road, if someone is challenging the health care individual mandate or the minimum coverage requirements, and there's a Republican president in the White House, and they find one federal district judge who holds that it's unconstitutional. I don't think the Supreme Court would agree with that. Not close, but suppose one district judge held it unconstitutional. You wouldn't want a situation where the government can say, well, we're just not going to appeal. Now, it'd be very different if they take the appeal and took a fairly bold step, and it's something the administration, I think, ought to consider down the road sometime in December or January when the full briefing is done, whether to tell the Court of Appeals that in the government's view it's unconstitutional. They're appealing because they believe the final decision ought to remain with the court. But now, they are going to appeal, and they are going to tell the court that in our view it's unconstitutional because it's harmful to the military.
Now, this is one of the reasons that I wanted to talk to you specifically about this today, because you've been making this case that for this specific type of appeal. Can you explain what precedent there is for the government doing that? For the government saying, listen, we recognize our responsibility as the Department of Justice to defend the nation's laws. We agree that this law that we are defending is unconstitutional. We are therefore still appealing it, but saying we think it's unconstitutional too. It seems like such a split the baby decision, but you say that it's been done before.
It has been done before. It's been done in 1945. It's been done by by President Reagan's administration in different circumstances. What the government does is says, look, we've got an act of Congress. We can't say for sure that the Supreme Court will invalidate it. There's no case right on point. So we feel like we owe it to Congress to make sure that the appeal is at least taken up to the Court of Appeals or to the Supreme Court. We're going to tell the court we think it's unconstitutional. We think you should strike it down. But we're going to allow others, members of Congress who support the law or other groups that support the law, to come in and appear as friends of the court and argue for its constitutionality. But we're going to say what we honestly think. And I think that's an option that will be open to the administration at some point in the briefing process. And indeed, once the president has said, with some support from the military, that he believes that it undermines the military to have 14,000 servicemen and women who have been separated from service since this Don't Ask, Don't Tell went into effect in 1993. 14,000 people we've lost their services, including skilled linguists and technicians and weapons experts. That doesn't advance military security, and any law that has this substantial effect on the liberty of individual Americans without advancing a governmental goal is unconstitutional. And the president can say, I've decided, in my view, that it's not necessary, it's harmful, therefore I'm going to tell the court I think it's unconstitutional, leaving the final decision to the court. We don't know what the court's going to hold. We don't know what the court's going to hold. So it's critically important to keep this in the realm of politics and to support candidates who support repeal of Don't Ask, Don't Tell, because the only sure way to get this done, since you can't rely upon the Supreme Court at the end of the day, no matter what position the Justice Department takes, is to make sure it gets repealed by Congress. And I think that's going to be the critical battle that we're going to face in the coming months.
I think the thing that is so uncomfortable about that is the idea that it is a constitutional matter, that people who support the repeal of Don't Ask, Don't Tell do so on the basis of essentially agreeing with this judge's ruling that this is unsustainable under any reasonable understanding of our constitutional rights. And therefore the idea that it ought to be up for a vote, that it ought to be up to whether or not John McCain's having a grumpy day about gay people or a happy day about gay people, rubs us the wrong way. And the court's ruling that this is not the court's ruling, if the government agrees with it, it seems to make sense that there's a jurisdictional concern that you don't want just a district court judge making policy for the whole country, but it does sort of feel like something that ought to be, if it can't be the president, then it ought to be some sort of constitutional declaration on this.
Well, look, if you and I were on the Supreme Court, and I think there are going to be plenty of votes on the Supreme Court to strike this policy down. And I think the case for striking it down as a constitutional matter is going to be stronger if the president can work his way to get the Defense Department fully on board. The more he's got the Defense Department to back him up and say that this is not necessary to advance efficient military security interest, the more likely it is that it will be struck down. So he's playing a very delicate game of trying to get the Defense Department on board to enhance the chances that it will be struck down, while he's also seeking legislative repeal. I still think at the end of the day, the one place where I may differ with them is that I hope at the end of the day they'll consider telling the court, look, we think it's unconstitutional.
One last quick question for you. If this does go to the U.S. Supreme Court, does Elena Kagan have to recuse herself?
I am aware of nothing that would indicate that she has participated in any of this litigation, but I just don't know.
All right, Walter Dellinger, head of the Office of Legal Counsel and acting Solicitor General during the Clinton administration. It's been a real pleasure to hash this out with you, sir. Thank you so much.
Thank you, Bob. You're quite welcome.